Good afternoon, friends. The weather is very cold, cool. Still, I made my mind to have a discussion with you on the important leading case which is in the syllabus of Advocate or Court examination of the Supreme Court of India. So I am going to share that leading case. Before going into the contents of the case, I may memorize you that during amendment of our Constitution, Wide Amendment Act 2002, 86th Amendment by done to our Indian Constitution, and Article 21 capital A was introduced. The purpose of this Article 21A was to solve the problems of the poor persons, children who were unable to pay fees. So the provision was there. And keeping in view this provision, further Right to Education Act 2009 was brought into picture. So this is the position. Now, if we go by the purpose of Right to Education Act of 2009, it focuses on to mandate 25% reservation of seats for children from economically weaker sections of the society. So this Act of Right to Education Act 2009 imposes obligation related to admissions, teachers' qualification, and infrastructure. To implement this act, the government directed the minority institutions to reserve 25% of the seats for economically weaker sections of the society, which is under challenge in this case law. I am talking about 33rd case law of the Advocate General Court titled Pramati Educational and Cultural Trust versus Union of India 2014. This is significant decision by the Hon'ble Supreme Court of India, particularly concerning the applicability of Right to Education Act 2009 to minority institutions. This judgment focused on the interplay between Right to Education Act and the constitutional provision granted to minority institutions under Article 29 and 30 of the Constitution. So there is interplay between Article 21A, Article 29, and Article 30. We all know the settled law is when any statutory provision goes beyond provisions of the articles of the Indian Constitution, they are checked to that extent. But when there the provisions of the Constitution itself interplay between them, then the only method left with the in judicial view is to read them harmonious to each other rather than striking down anyone, as the court has no power to struck down the provisions of the Constitution. So, going in detail, let us explore the whole provisions and end result of this case law. Let us dive deep into the constitutional provisions. Now, Right to Education Act 2009, it mandates that private, unaided, and aided schools should reserve 25% of seats for children from economically weaker sections and disadvantaged groups. The Act also imposes obligations related to admissions, teachers' qualifications, and infrastructure. Challenge by educational institutions. Certain private, unaided institutions, including minority institutions, challenge the application of the RTI, Right to Education Act, arguing that it violates their right under Article 91G that talks about freedom to practice any profession or carry out any occupation, and Article 29 and 30. These two articles relate to rights of minorities to establish and administration educational institutions. Now, first we will see the provisions of these two articles. Article 29, subclause 1, protects the rights of the citizens to conserve their language, script, and culture, whereas Article 30, subclause 1, gives minority the right to establish and administer educational institutions of their choice. Before going further deep into the analysis of this case law, we are also having previous judgment on this issue by the same court. That was in Society for Unaided, not aided, unaided private schools of Rajasthan versus Union of India, that is of 2012. Hon'ble Supreme Court, in this case, upheld the constitutionality of the Right to Education Act 2019, what exempted unaided minority schools from its purview. This is the purview. However, the broader implications for other minority institutions were not addressed fully in this case. So there was a lot of gray area, untied area in the judgment. So the key issues under this case law are: can the obligations imposed by Right to Education Act 2019, such as the 25% reservation for economically weaker sections and disadvantaged groups, be applied to minority institutions? Second is how to tackle the conflict between right to education and minority rights. By the RTI Act, by the Right to Education Act 2019, infringes upon the fundamental rights of minority institutions under Article 29 and 30. So the Supreme Court gave its observation. Firstly, the court reaffirmed that minority institutions are protected under Article 29 and 30, which grants them the autonomy to establish and administer their institutions without interference from the state. The court held that Right to Education Act cannot apply to minority institutions, whether aided or unaided, as it would interfere with their right to administration and preserve their distinct entity. The judgment emphasized the need to balance the objective of the Right to Education Act with the constitutional protection granted to minority institutions, noting that the minority rights must prevail in cases of conflict. Now, there is Article 21A, which was added by Amendment Act of 2002, by 86th Amendment. The court clarified that while Article 21A, right to education, imposes an obligation on the state to provide free and compulsory education, that cannot override the rights of minority under Article 29 and 30. So court clearly clarified, no doubt there is Article 21A gives power to the government to provide free education, but it is not at the sake of Article 29 or 30. You cannot overrule the Article 29 and 30. So this judgment, through this judgment, minority institutions, both aided and unaided, are exempted from the provisions of the Right to Education Act, including the requirement to reserve 25% of seats for EWS and disadvantaged groups. So they were given a relief. No doubt they were given a relief. What the judicial view does not say that Right to Information Act is not valid. They upheld the validity. So validity of the Right to Information Act was upheld for all non-minority private schools and government schools. So we can say net result was your provisions can be put on other private institutions, not on minority institutions. So, nutshell, the significance of the judgment is reaffirmation of minority rights. The judgment reinforced the autonomy of the minority institutions to administer their educational establishments without undue state interference. It limited the Right to Education Act. It marked a clear boundary for the application of Right to Education Act, ensuring it does not infringe upon the constitutionality protected right of minorities. Now, the ruling shaped the implementation of the Right to Education Act, particularly in ensuring that its provisions are applied in a manner consistent with the constitutional provisions. Now, there comes the criticism. Critics argue that exempting a minority institution from the Right to Information Act deprives economically and socially disadvantaged children of opportunity for inclusive education. And it further said there are concerns that minority institutions may misuse minority status and other institutions may misuse minority status to avoid obligation under the Right to Education Act. So, concluding by this topic, we can say that the Pramati Educational and Cultural Trust versus Union of India case struck a balance between the right to education and constitutional protection afforded to minority institutions. It clarified that the limits of the state's role to regulating education, ensuring the autonomy of the minority groups while upholding the broader goals under the Right to Education Act. So the children between the age of 16 to 14 were granted free education, but not at the sake of minority institutions. They were given free, government was given free hand to implement this Right to Information Act in other private schools which do not come under Article 29 and 30. Friends, while explaining the contents of this act, I may have used different years due to absence of mind while speaking. The Right to Information Act is of 2009. Please, I am clarifying. Right to Education Act is of 2009. That's all. God bless you all. See you again.